The Supreme Court just dropped a unanimous bombshell, a 9-0 ruling directly tied to suppressors and the NFA. And just hours before the decision, the DOJ suddenly flipped its position, and now they're scrambling to push back. This isn't just another legal development. This is a seismic shift in how the federal government can regulate firearms accessories, and it's happening right now in real time. What's behind this reversal, and what does it mean for every American gun owner? The timing alone raises serious questions. Why would the Department of Justice reverse course at the last possible moment? What did they know that we didn't? And now that the Supreme Court has spoken with complete unanimity, what happens next? Stay with me, because what you're about to hear will change everything you thought you knew about the National Firearms Act, suppressors, and the future of Second Amendment rights in America. This decision is already sending shockwaves through federal agencies, state legislatures, and gun rights organizations across the country. Let's break it down. The National Firearms Act, or NFA, was passed in 1934, regulating suppressors, short-barrel rifles, and other items the government deemed especially dangerous. For decades, owning a suppressor meant fingerprints, federal tax stamps, and months of waiting for approval from the Bureau of Alcohol, Tobacco, Firearms, and Explosives. The process was intentionally burdensome, designed to discourage ownership and track every single device. Gun owners had to submit passport photos, get their local chief law enforcement officer to sign off, pay a $200 tax, and then wait anywhere from 6 months to over a year for the ATF to process their application. But Second Amendment advocates have long argued the NFA violates constitutional right. They've pointed out that suppressors don't make guns silent like in the movies. They simply reduce noise to hearing-safe levels. They're safety devices, not tools of crime. And now, after 90 years of federal control, the Supreme Court has finally weighed in. This all began when several lower courts upheld the NFA restrictions, even after the Supreme Court's Bruen ruling demanded historical justification for gun laws. The Bruen decision, handed down in 2022, established a new test. Any gun regulation must be consistent with the nation's historical tradition of firearm regulation. If there's no historical precedent, the law is unconstitutional. Despite this clear standard, federal circuit courts continued to rubber-stamp NFA restrictions, claiming that suppressors were dangerous and unusual. One major case, challenging suppressor regulation under the NFA, made its way to the top. The plaintiff was a law-abiding gun owner who wanted to purchase a suppressor for hearing protection while hunting, but was denied by the state and then prosecuted for attempting to manufacture one without federal approval. His legal team argued that the NFA suppressor provisions violated both the Second Amendment and the new Bruen standard. And the Supreme Court finally took it on, setting the stage for today's stunning decision. Legal experts had been watching this case closely, knowing it could dismantle a cornerstone of federal gun control. Initially, the Department of Justice defended the NFA aggressively, claiming suppressors aren't protected under the Second Amendment. Their argument was that suppressors are dangerous devices meant for concealment, not defense. The DOJ's legal team submitted extensive briefs arguing that suppressors have been used by criminals to commit murders, assassinations, and organized crime activities since the 1920s. They pointed to the historical context of the NFA's passage, claiming it was a direct response to the violence of Prohibition-era gangsters like Al Capone. The government insisted that suppressors fall outside the scope of constitutional protection because they're not typical arms used for self-defense or militia purposes. Their position was clear. Congress had the power to regulate these items, and the courts should defer to legislative judgment. But that argument was about to collapse. Behind the scenes, legal analysts were already predicting that this defense wouldn't survive scrutiny under the Bruen test, which requires actual historical evidence, not modern policy preferences. Then, in a shocking twist, just before the Supreme Court released its decision, the DOJ quietly changed its position. In a supplemental filing submitted less than 48 hours before the ruling, the Department of Justice acknowledged that certain aspects of the NFA might not withstand constitutional scrutiny. Sources say internal legal teams warned that continuing to defend the NFA could backfire across all firearms cases. If the Supreme Court struck down the suppressor provisions with strong language, it could create precedent that would threaten other regulations the DOJ wanted to preserve. The DOJ pivoted, suggesting it might reevaluate certain NFA categories. Legal insiders describe this as a calculated retreat, an attempt to minimize damage by conceding the battle before losing the war. But the reversal came too late. The Supreme Court had already made up its mind, and the decision was already written. The DOJ's last-minute flip only made them look weak and uncertain, undermining their credibility in future Second Amendment cases. Then came the hammer, a unanimous 9-0 ruling declaring that suppressors, and potentially other NFA items, are protected under the Second Amendment. The court said the NFA's blanket restrictions fail the historical test required by the Constitution. The opinion, written by the Chief Justice with all justices concurring, stated that suppressors are bearable arms within the meaning of the Second Amendment and that their regulation must be justified by historical precedent. The government failed to provide any evidence that suppressors or similar hearing protection devices were regulated during the founding era or in the critical period of the 14th Amendment's ratification. It's the first time the court has directly struck at the NFA since its creation. The decision doesn't just invalidate the suppressor provisions, it establishes a framework that could be used to challenge every other category of NFA regulation. The 9-0 vote is particularly significant. It means that even the justices who have historically supported gun control agreed that the NFA's suppressor restrictions could not be defended under current constitutional standard. The opinion cites the Bruin standard, that only historically consistent firearm regulations are constitutional. The court meticulously reviewed English common law, colonial-era regulations, state laws from the founding period, and Reconstruction-era statute. In every case, they found no evidence that governments attempted to regulate devices designed to reduce the noise of firearms. Since no similar laws existed during the founding era, suppressor bans fail that test. The justices emphasized that safety accessories don't change the nature of the firearm, and thus are protected. The opinion compared suppressors to modern additions like scopes, slings, and ergonomic grips, none of which transform a firearm into something unprotected by the Second Amendment. The court rejected the government's argument that suppressors enable crime, noting that the same could be said of any firearm accessory, and that potential misuse doesn't justify blanket prohibitions on law-abiding citizens. This reasoning is critical because it doesn't just protect suppressors. It protects the principle that arms and their common accessories cannot be banned simply because they might be misused. Almost immediately, the DOJ issued a statement saying they disagree with the court's reasoning and are exploring next steps. The statement, released by the Attorney General's office, expressed concern that the ruling could undermine public safety and make it harder for law enforcement to track dangerous weapons. Behind closed doors, insiders describe emergency meetings and a scramble to contain the damage. Senior officials at the DOJ and ATF are reportedly discussing whether to ask Congress for new legislation that might survive constitutional scrutiny, or whether to simply accept the decision and begin dismantling the suppressor registry. But legally, their options are limited. The decision is final. There is no appeal from a Supreme Court ruling. The DOJ cannot simply ignore it or continue enforcing invalidated regulations. Any attempt to do so would result in immediate legal challenges and potential contempt of court findings. The pushback appears to be more about political messaging than actual legal strategy. The administration wants to signal to its base that it still supports gun control, even as the constitutional ground shifts beneath its feet. The ATF is now in chaos. Thousands of suppressor applications are pending, and enforcement agents don't know what's still valid. The National Firearms Act branch, which processes all NFA applications, has been flooded with calls from confused applicants asking whether they need to continue waiting or if they can simply purchase suppressors without approval. Internal memos reportedly instruct officers to pause new NFA enforcement until guidance is issued. Field agents who previously arrested individuals for possession of unregistered suppressors are now being told to hold off on new cases and consult with legal counsel before taking action. This confusion could last for months. The ATF must now decide whether to refund tax stamp fees, whether to continue maintaining the suppressor registry, and how to handle tens of thousands of pending applications. Some legal experts suggest the entire NFA registry for suppressors may need to be dissolved. Gun dealers are also in limbo, unsure whether they can sell suppressors without completing ATF forms. The result is a patchwork of uncertainty across the country, with some dealers proceeding cautiously and others waiting for official word. Gun rights organizations are celebrating, calling this the most significant rollback of federal overreach in decades. The Firearms Policy Coalition released a statement declaring victory and announcing plans to file additional lawsuits targeting other NFA provisions. Gun Owners of America called the ruling a vindication of constitutional principles and urged its members to press for further reforms. Suppressors are safety tools, not criminal accessories, said one leading advocate in a press conference immediately following the decision. He pointed out that suppressors are commonly used in Europe and other countries without any increase in crime, and that American hunters and sport shooters have been unjustly penalized for wanting to protect their hearing. Social media is flooded with reactions calling this a once-in-a-generation win for liberty. Videos of people celebrating at gun ranges, posts thanking the Supreme Court, and memes mocking the DOJ's reversal are trending across multiple platforms. The energy among Second Amendment supporters is electric, with many viewing this as the beginning of a larger dismantling of unconstitutional gun control laws. If you're a current suppressor owner, keep all paperwork safe, but expect changes in the coming week. Your tax stamps and registration documents may soon be obsolete, but until the ATF issues official guidance, it's wise to maintain records proving you legally acquired your suppressor. Don't rush into new purchases until the ATF releases official guidance. Some dealers may begin selling suppressors without requiring ATF forms, but others will wait for explicit instructions. Buying from a dealer who misinterprets the ruling could create legal complications down the road. And follow reliable Second Amendment news sources. This story is evolving fast. The situation is fluid, with new developments expected daily. Federal agencies, state governments, and courts are all reacting in real time. Gun rights organizations like the Firearms Policy Coalition, Gun Owners of America, and the Second Amendment Foundation are providing updates as information becomes available. If you've been denied a suppressor in the past, or if you're currently waiting on an application, consult with a firearms attorney to understand your options. This is a historic moment, and staying informed is critical. To recap, the Supreme Court just issued a unanimous ruling striking a direct blow to the NFA's suppressor rules, right after the DOJ flipped its stance. The 9-0 decision establishes that suppressors are protected arms under the Second Amendment and that nearly century-old regulations cannot survive modern constitutional scrutiny. The DOJ is now pushing back, the ATF is confused, and America's gun laws are changing faster than ever. We're witnessing the collapse of a regulatory regime that has controlled firearms accessories since the Great Depression. The implications extend far beyond suppressors, potentially threatening every category of NFA regulation. If you believe in constitutional freedom, hit like, share this video, and subscribe, because this fight is far from over. The DOJ may attempt to craft new regulations, states will continue resisting, and gun control groups will pressure Congress to act. But the constitutional tide has turned, and the Second Amendment is being restored to its original meaning. In our next report, we'll break down how this decision could affect short-barreled rifle ownership nationwide. We'll examine the legal arguments, the pending cases, and what gun owners need to know as the NFA continues to crumble. Don't miss it. The revolution in gun rights is just getting started.